Hello, good evening and welcome to another program on Law and Order. A program that features experts in law and an area of law every week to bring you awareness of that area of law. Now, the Civil Procedure Code, which you have all heard of, has been in operation in Sri Lanka for nearly 100 years or a little bit more. But is it achieved its purpose relating to the modern day? Why does the Civil Procedure Code need amendments, or does it need further amendments as well? Tonight, we are going to go in depth into the present amendments which were done in the Civil Procedure Code with an expert attorney on that area. My guest today, therefore, is President's Counsel Kushan Alwis. President's Counsel Kushan Alwis is a practitioner and a specialist in the areas of this law. Thank you very much, sir, for taking our invitation with your busy schedule and coming for the show. How are you doing?
Thank you, Shanaka. Pleasure. It's an honor and a privilege to be invited to Rupawahini.
Yes.
And thank you.
Thank you for coming again. Now, let's start off with this obvious question. Why were the amendments necessary for the Civil Procedure Code?
Mainly, Shanaka, it was due to loss delays. It was a widely spoken subject. And as you may be aware, 95% of civil litigation in the country is governed by the Civil Procedure Code. So therefore, it was necessary to look into the workings of the Civil Procedure Code and to see why the loss delays were occurring and what was the remedy that is available. Right. Now, like you said, the Civil Procedure Code has been in existence from about 1889. There had been about 45, 46 amendments to the Civil Procedure Code from time to time, which was all intended to make it more people's friendly, or sort of enhance the legal system and to enhance speedy litigation, as well as there was a short period from about 1973 to about 78 where the Civil Procedure Code was not there. It was replaced by the Administration of Justice Law. Then in 78, I believe the Civil Procedure Code was reintroduced. Now, the main complaint of litigants, especially I am in the field of civil or civil work, so is the loss delays. So this amendment, which was brought in, that is number 8 of 2017, is geared to address this problem of loss delays. And so therefore, several progressive steps have been introduced.
Right. So what were the sections that were amended on Civil Procedure Code? I know it was hundreds of sections.
Civil Procedure Code technically has from up to 839, but some sections in the middle are not operative. But all in all, there is over 700 sections. Right. But certain sections where there were bottlenecks have been addressed. If one takes, one of the main things was the pre-trial steps. Right. Now, in foreign jurisdictions, this pre-trial is a very important step, which has been successfully implemented in several foreign jurisdictions. And that is geared to ensure that towards amicably settling the matter, if not, if the matter is proceeding for trial even, to get to the crux of the problem or the dispute without having unnecessary, or I would say very technical objections, so that there is a judge, in this case of the amendment, or in other areas it would be other jurisdictions, it may be a master of the role or master, or sometimes a registrar. It depends, different jurisdictions call the judge different names. So those it is those pre-trial steps are, one would say, the main focus of this amendment.
Okay. The pre-trial, what happens in the pre-trial stage? If you were to walk me through how does it happen now, as opposed to how a case was filed before?
Yes. What happens is, as introduced by the amendment number 8 of 2017, once the answer is filed, a date has to be given which is not earlier than 3 weeks and not exceeding 2 months for pre-trial steps. So that is, once answer is filed by a party, or one would say, if there's a claim in reconvention, the replication, a date not less than 3 weeks, not more than 2 months is given for pre-trial. Now, at the pre-trial, there are several matters which a judge has to go into. Now, for instance, in terms of the section which deals with pre-trial, that is the new section 142A onwards, the judge has to, there are several matters, if one would say 142D, ascertain the jurisdictional issues, then get to what exactly the matters in dispute are, then obtain admission of facts and documents, then consolidate 2 or 3 pending cases if there are connected cases, then identify the number of witnesses based on admissibility and relevancy. Then if there is a necessity, we'll say, of some court expert evidence, that will be attended to. Then, this is a very important part, the judge is supposed to actively engage himself in seeing whether there is a possibility of the parties entering into terms of settlement. Now, why I am stressing on this is, this has another matter which I will be dealing a little later with. Now, it says, assisting the parties to arrive at an adjustment, settlement or compromise or other agreement with regard to the matter in issue in such action, and may for that purpose suggest terms of settlement which in his view is reasonable, having regard to all circumstances in the case.
Right.
So, basically the judge is
more
actively
involved in the case.
Involved in the case.
Right.
So, this whole exercise is a very good thing. But however, the amendments which have been brought in, the time frames that have been given, taking into consideration the circumstances and the backlog of work in the courts, there are a few reservations on those matters. Even so many practicing lawyers find it a little, it's just not a case of rushing the matter through, but still those time frames which have been given are rather, it could have been a little more flexible, or it would have been a little more longer.
Right. So, the pre-trial, that process which you explained, within how many days does it have to conclude?
No, it says that once it commences, it must conclude within 3 months.
3 months.
So, the first date for pre-trial is usually given basically 3 weeks after, not later than 2 months. Once it commences, it has to finish within 3 months. And if a date is being given or it is being refixed for some reason, the adjournment should not be more than 4 weeks.
Right.
In between.
In between.
So,
okay. Now, if the suggested settlement by the judge is not achieved, then it continues beyond that as a usual trial, framing the issues, admissions, or how does it go?
Issues and admissions have to be filed 14 days prior to the pre-trial.
Pre-trial.
Yes. So issues and admissions, sorry, it's either way about admissions and issues are settled at the pre-trial.
Okay. So if only the settlement is not entered, then it is fixed straight away for trial.
It is then, no, there is a section, this is where I said I will deal with it a little later.
Right.
This amendment speaks of the case being called in the trial court for the matter to be fixed for trial. Now,
just as it was before.
Just as before, but here there is a grave implication more than that. Now, in foreign jurisdictions, the judge who usually hears or conducts the pre-trial never hears the trial.
Right. Okay.
Because he is supposed to actively participate and find out whether it's possible to enter into a settlement.
Right.
And he is also given basically to suggest terms of settlement which in his view are reasonable. So, it is natural that as any human being, if once the judge thinks that it is the pre-trial judge, but when I mean the judge, suggests something a reasonable settlement, and one in his mind is reasonable, and one party rejects that, maybe unreasonably, it may, if the judge holds with the other party, the party which rejected the settlement may come off with the idea or view that it is because I didn't accept the settlement, or there can be other implications. That is why
that there would be some sort of a conflict of interest.
I wouldn't call it a conflict of interest. But in foreign jurisdictions, they've been very, very careful.
Because it can be biased, interpreted as bias.
Yes, I wouldn't go as far as using the word bias, but it can, the party who loses may come with the idea that justice had not been manifestly. So therefore, that is why now in putting down, even sort of in enacting this amendment, otherwise, if it was the pre-trial judge who was supposed to hear the trial or conduct the trial, he could have fixed it straight away for trial.
Exactly.
But section 142I, pardon me, 142I says the judge conducting the pre-trial hearing shall forthwith appoint a date within 14 days of such date for the case to be called in order to fix the date for trial of the action in the trial court. So, by implication, it gives the impression that the judge who conducts the pre-trial is not the judge in the trial court, but with the constraints of our the financial constraints and other constraints, except for maybe one or few of the major stations like Colombo, Kandy, or we say Matara, where there are more than 2, 3 or 4 judges, district judges. In other places, it may not be practicable to have a pre-trial judge and a trial judge. Because for that, then the infrastructure has to be there for that.
So what you're saying is legislature has intended and facilitated, but because of practical reasons, we are unable to achieve that. Something the infrastructure.
Impliedly, it could be argued that the legislature had, in its wisdom, while enacting, had basically thought of having sort of the pre-trial judge and the trial judge or the separate, 2 courts being separate. In fact, it should be, because in no foreign jurisdiction does the pre-trial judge conduct the trial. But unfortunately now, even in places like, even in Colombo, although we have almost 9 district courts, the pre-trial and the trial is conducted by the one and same judge. Now a classic example is now, in the time I took courts and came, each of the district courts did their own role all their calling cases, the land court will say had roll day was on Monday, the partition of the money recovery court was on Tuesday or something like that. Now there is a roll court. So all the calling cases mainly for filing of answer and other steps are in the roll court, and then it's sent to the particular trial courts. So similarly, if one is to get or the maximum use of these pre-trial steps, I think as much as possible we should have a division so that the pre-trial judge and the trial judge should not be the same person.
Yeah. So you also mentioned that in the start that one of the reasons for these amendments was necessary was because of the loss delays.
Yeah.
Now the pre-trial stage comes after the answer.
After the answer.
But there is, as you can see in practice, people, some practitioners, and due to the lack of court time also, filing an answer also takes sometimes about a year after the plaint, and it invariably happens. So that delay continues, if I may say that.
No, that offers again the roll court that can control. Basically now that is not allowed, like they do not give indefinite dates for answers.
Right. Has there been amendment for timing for filing of answers?
Filing of answer, as far as I can, this thing I don't think there was a...
It's as usual.
As usual, I believe that was not amended on that matter.
Right.
But because sometimes there are circumstances which may not, I don't think you could sort of give a specific, it will depend on, now we'll say about 2 or 3 defendants. So it depends if summons is served on one defendant on a particular day, then if there is another person living abroad in a foreign jurisdiction, so you have to serve summons there, so you can't sort of give a strict date. But of course, it would be, I think the roll court or the judge should sort of take into consideration those matters. But personally, I feel more than 3 months should not be given in any case,
right.
Unless there is compelling reasons to do so.
Yeah. Now, does this apply across the board for all type of cases, or is it any case that comes to district court?
Not necessarily, because I think the DR, or what you call the debt recovery, it won't be because the debt recovery has a different procedure,
right?
And so those that it won't but 95% of the cases or 90% of the cases will be covered.
Right.
Then the Partition Act has its own procedures because appointing a representative, actually the legal representatives, that what is there in the partition law is what has been brought in 8 of 2017, the amendment, where basically when you file proxy, you have to nominate legal representatives in the case of death.
Right. Now, sir, the other area is that you mentioned that there are some reservations you would like to mention later with regard to this amendment or the totality of the amendments of the civil procedure.
Yes, this amendment seems to have been hurriedly done.
Right.
Because as you are aware, in terms of our law, basically it's the law that is published in Sinhala that prevails. Then any inconsistency between the Sinhala and the Tamil text, the Sinhala text prevails. There is no mention whatsoever of English translation of it, or any legal validity given to an English translation. But when one takes these amendments, it looks as if though this has been drafted in English and thereafter translated to Sinhala, which now for one example, I would say, is the fact, now the section 80A speaks of now the words in section 80A1 speaks of grave and irremediable injustice. Then section 80A2 speaks of manifest injustice. Now, in terms of the English language, grave and irremediable injustice and manifest injustice cannot have the same meaning. Now, for instance, because otherwise if it was meant to be the same meaning, it should have been the same words.
Right.
But now in Sinhala, it basically they speak of බරපතල සහ අප්‍රතිකාරී අසාධාරණයක්. That is grave and irremediable injustice. Then for manifest injustice, the word used is බරපතල අසාධාරණ.
Right.
So it seems to be the translation, I think, is much to be desired and also a very compelling thing. Now, you see, in civil litigation, you have to file proxies. You can't file a party can appear in person, but otherwise, if a lawyer is to appear, so then there is a situation of sometimes revocation of proxies. So when it comes to revocation of proxies, the English Act says that if the lawyer wants to revoke, that is that it must be in writing, signed by the client, filed in court. And the Roman 2 says, with the leave of court, having given 30 days notice to the client. Now the Sinhala Act, or the Sinhala, actually this is the Act, speaks of ho, or, one of the two.
None of the two. Yeah.
But then when you take the bill, or the English, the word or is not there. So like that, if there are several, there's a whole lot of things. And then also the other thing is, sections in the Civil Procedure Code, this amendment has been certified on the 7th of June 2017. That is, as you are aware, in terms of Article 81, within brackets 1 of the Constitution, the bill becomes law upon the Speaker's certification.
Yes.
So this has been certified on the 7th of June 2017.
Yes.
And the section says that all matters which have been filed, that's section 17, filed in the district court, but in respect of which no date has been fixed for trial, shall be the subject of provisions as of on the day of coming. So basically, any case that had not been fixed for trial, this Act will apply. Now, in this Act, some important sections have been repealed.
Yes.
146, 147 and 148. Now, there are no transitional provisions here, which says what happens to cases which have been fixed for trial, but have not been in fact taken up for trial before the 7th of June.
Right.
Now, section 146, 47 and 148 have been repealed. So, that is not law anymore.
Yes.
And this Act applies only to cases which have not been fixed for trial prior to the 7th of June.
Right.
So, there is like that, there are several matters. So, but let me say this all in all, it is a very progressive piece of legislation, but I think lawyers' views have to be taken into. I think the Bar Association, I am told the Bar Association is also now going in writing a report on this matter and submitting. I think with a few amendments to this, this Act number 8 of 2017, we should be able to achieve this. So, I think it's a very good thing, but it needs amendments.
Thank you very much, sir, for taking time off and giving us a very elaborate explanation about the amendment to the Civil Procedure Code number 8 of 2017. And thank you for joining us. We hope to see you once again in this show with a further show.
My pleasure. Thank you very much.
Thank you. Thank you. That's Law and Order for you today. We'll join you next week with another edition of Law and Order. In the meantime, you can join our conversation on the Facebook page of ours. That's Facebook/Law and Order Channel I, Facebook/Law and Order Channel I. Or you can go to our page, that's channeli.lk, and go to the drop-down menu, pick Law and Order, and watch these shows all over again. I'll see you next week with another program. Have a good night and a good weekend.